Okay, we are live. We're back. I refreshed everything. I got it all ready, and then I don't know what happened with StreamYard, but um, I had to like redo my whole login and whatever. Okay, so we're back. Court is not back yet from their break. I'm hoping they come back with the jury. I'm running out real quick. I will be back in 15 minutes. Have to take her to preschool. I am praying and hoping everything stays clean. There's no glitches, there's no pausing. I hope it all works out. I will be right back. I'm going to put this full screen. Court is live. So as soon as they get started, it should just come right back on. I will be right back.
The record, please. Mr. Bloodworth, before you weigh in, I need to fix a misstatement that I made while discussing Detective O'Driscoll's potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because it would be hearsay. That is overly broad. To the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or a prior consistent statement under 801D1B, it is categorically not hearsay and he can relate it. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P. 3rd 867, footnote 8. There, the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are to come in, and the Utah Supreme Court expressly declined to reach the issue. They did not rule that they must come in through the declarant. So, as I sit here today, there is no authority for the proposition that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination. Indeed, it is defendant's cross-examination of Ms. Lauber that creates the foundation for admission of consistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here, and prior consistent statements based upon an express or implied charge that Ms. Lauber was acting from a recent improper influence or motive, to wit, pressure applied by, among others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that. There is not a Crawford problem here. I also have another thought regarding the transcripts going back, if you want to discuss that.
So maybe we can get the court's thought and then I can incorporate that into the state's position.
Sure. Under Wyatt v. State, 2021 UT 32, under paragraph 21, the Utah Supreme Court abrogated the common law rule that prevented testimonial transcripts from going back into the jury room based upon a concern of undue influence, on the basis that Rule 17K of the Utah Rules of Criminal Procedure does not allow for any categorical exceptions to exhibits going back with the jury, because the jury may take with them, quote, all exhibits, end quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury, end quote. Now, typically that's guns, knives, poison, explosives. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract some unwanted attention on appellate review. But under Wyatt v. State, 2021 UT 32, there's no categorical exclusion of them. Take it from there, Mr. Bloodworth.
So, Your Honor, it's the state's position. I know I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there is no Crawford issue, in part because of the 801D1 requirement for opportunity to cross has been satisfied in this instance. It's the state's position that the defense, to the extent they want to recall Carmen Lauber, is not burden shifting. It's just a defense strategic choice. And it's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the midpoint of Jeff O'Driscoll's examination. So I propose our next witness is Chris Kochadimos to clean up some stuff from yesterday. I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us till lunch. I may have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred? And to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root. And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be the root anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's waste time. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
All right. Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
We stand by our objection that allowing prior consistent statements to come in without a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and Crawford versus Washington. It also violates her right to due process. under the Utah State Constitution and the federal Constitution. She is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want that to occur?
I-
Do you want to just play the interviews with Ms. Lauber?
Sure, we could do that. We could just play them all. They're 7.5 hours, but if that's how we want to do it.
And tell me why you want to do that.
Because there are numerous other portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
We're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it
Which
all go
specific
back.
part, you got to be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
Forgive me, you've pivoted again. It's stay away from going back. Let's just stay on publishing. So I understand defendant's position to be if any of it's published, all of it has to be published.
Correct.
Okay. In response to that, the state, as I understand, is suggesting I'm inferring in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings and then allow counsel to make whatever arguments they want to make about, you should go back and listen to this part because you'll see this is what was happening. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No.
So
Our
you're
objection
saying publish.
stands.
Let me start again. Imagine that your objection to publishing anything is overruled, and that's the world you're living in. How do you want to proceed from there?
I mean, I think I said that. Then it should all go back. Or
Again, you keep skipping to going back. I want you to talk about publishing for a minute.
It's showing up on the screen.
so my hesitation is just efficiency. Like I said, it's over 7 hours worth of video. But if that's how the court wants to do it, then yes.
No. That's what I'm asking you. So imagine, here, I'll just make a ruling. I have considered carefully the authorities cited by defendant and the state. I've looked at the text of Rule 801. Ruling is a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court under oath, was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement. The court has not seen any authority for that proposition. So to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So Ms. Lewis, take it from there. Some of her prior consistent statements as designated by the state are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well, I
We
guess-
could just publish. We could admit and send back into the jury room. Speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well, I think there's a basis to do so. It gives me the willies, quite frankly, and that's why Mr. Bloodworth, out of an abundance of caution, is saying prophylactically to prevent any appellate issue there, we would just publish. But if the defendant believes, Judge, if you do this, the least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them, you could do that by stipulation.
No, I don't want to do that. I think that even though it's not efficient, the appropriate way is if any of the interviews are going to be published, they all need to be published.
Okay, only published.
Correct.
All right. I appreciate your position. Mr. Bloodworth, take it from there.
Your Honor, the state moves to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63R. I think beyond so, I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and as a compromise, the state is fine with sending full videos back or some mix of publish the narrow pages and send a full video back. But the notion of publishing nearly 10 hours of interview is, I don't think it's productive. I think it's a waste of the jury's time.
Okay. Ms. Liz.
We object to it all going back. It's the same problem. The problem arises is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts of what the state has designated?
Because there are, I mean, I already made my issue or raised the issue about the May 10th.
We'll get there
Transcript.
specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now, every specific part. But there's a lot that's being left out, and a lot what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it she was cross-examined on, but there's a lot more statements like that she was never cross-examined on.
Well, that's choices defendant made, though. So here, in order for me to include additional material, there have to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other portions, but I have lost the opportunity to do that.
You haven't, but that's okay. You can certainly have access to this witness.
Well, I think we've made our record on that.
Are there Rule 106 portions you want to add, having reviewed the designations?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts with the officers, how the officers treat her. There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet, but there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced. There's a lot of it.
I know, but you're not giving me which ones they are.
It's because, I mean, all of them.
Okay. All right. That is hard to rule on because it can't be all.
Why not?
Well, certainly your position isn't that every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
It shows an arc.
That's the state's point.
Right. I know. And now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what we would. I mean, we want all of it. If you want me to go through all 1,000 pages again and try and figure that out, I mean, guess we can find some time to do that. But
okay. So, Mr. Bloodworth, as for today, how does the state propose to proceed?
So I propose we call Chris Cotodemos. I then will call Jeff O'Driscoll. We will get to maybe, 45 minutes into his argument before this will become an issue.
Okay.
My sense on timing, Your Honor, is this doesn't become an issue till a lunch break.
I'm not sure what's going to change between now and then, though, in terms of the issue of whether to play everything or just the parts that the state has designated under Rule 801D1B.
Fair.
So, all right. The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying. In response, defendant does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B. And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does. And that does not provide the court with a sufficient basis to rule one way or another whether other additional portions of these prior interviews are required to be included under Rule 106. Based on the record currently before the court, and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
No, Your Honor.
Ms. Lewis?
Yes, Your Honor. If we actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday morning.
Okay.
Your request for a 2-day continuance is denied.
Ask for a 1 day. Ask for 1 day.
All right. A 1-day continuance then.
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah.
Mr. Bloodworth.
Your Honor, the state objects. Not only did the state file the motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber testified. I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
All right. And Ms. Lewis, you'd be filing something in writing that had additional either Rule 106 inclusions or some identification of where the state has over-designated things, correct?
Yes.
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yes.
That is so slow. There's just no way this is going to work. There's no way we can edit the video.
I'm not tracking, Your Honor.
Each of these transcripts corresponds to a video of an interview, correct?
Correct.
It would seem that watching and listening to the video is more efficient than reading the transcript.
Oh, 100%, Your Honor. Based on the ruling right now, like 2 minutes ago, we have launched our video editor to create the video now of the narrowly tailored portions. That's how we would publish them. Is by playing the video.
Okay. All right.
One suggestion could be if the state wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll, and maybe through appropriate direct examination, they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we can do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it.
Okay.
Let's just cut to that chase.
All right. Folks, give me 5 minutes. Actually, just give me till 11. Okay. We're in recess.
The judge is so over it. He is so over it, and I don't even blame him at this point. I want Bloodworth to drop this whole argument. I don't think the jury is going to care about Carmen Lauber's prior consistent statements. I understand Bloodworth wants to put these in to prove Carmen Lauber was not lying. Her story has remained consistent. I understand that. I just don't think it is necessary. I think Carmen's testimony has been corroborated enough by the GPS, the cell phone data, showing the meetups happen, showing the drug deals happen. I just don't know what more they need to corroborate out of her to actually make this big of a deal out of it. And if I was the jury, I would be livid right now, sitting back in the jury room. They were supposed to start an hour and a half ago, and then now they're talking about potentially having a delay. The 2-day continuance is absurd. I'm so glad he shut that down as fast as he did. I don't understand why Bloodworth is pushing this issue. He needs to let it go. Okay. My jaw hit the floor when I heard her say we want a 2-day continuance. But I also don't blame Bloodworth as much as I blame Lewis for just being difficult. She's like, last week, Bloodworth wanted to admit all of the transcripts. She said no. So now here we are. After all of this, she's back to saying, just do it all. We want it all in. It doesn't work like that. Whew. They knew this was an issue, and she made it a big deal last week when Bloodworth wanted to do this and put it all in, and she was like, no. And then now, Bloodworth redacted 800 pages, and she's like, nope, just put it all in. It's like, you cannot have your cake and eat it too. Pick one or the other. Quit shifting arguments. And I think that's why the judge is so frustrated, because they pivot so much, and like it's literally like watching, what's that called, ping pong, back and forth, because she starts at one place, does a 180 just to end back up arguing the same thing she started, and it's so confusing. Emily Payne says, well, and they're gonna go through 10 hours and then submit something to the judge. Is he supposed to not sleep tonight? Oh, this judge reads everything. He is so good. I guarantee he has lost so many hours of sleep over this darn case. But he also is appointed to the civil cases as well as the other case with 26 counts. So he is very familiar with the filings in this case, the backstory on the civil side, the probate side, and the criminal side. He knows it all forwards and backwards. But they're just being difficult at this point. And I don't want to blame Bloodworth, but at this point, I want Bloodworth to just move on, because it is extremely frustrating. And it seems like nobody's considering the jury's time. They should be in court every day at freaking 8 a.m., 7:30 at that fact, to get this figured out instead of having the jury wait, because now they will have been waiting an hour and a half just to come back and probably wait some more and then get sent to lunch break. I'm mad for them. And I'm mad that it's now 1 p.m. and we have not heard any testimony today. Granted, it's 11 a.m. there, but still, give me a break. Yeah, you might as well just go to lunch at this point. Also, we thought O'Driscoll was going to be last, and turns out they're calling back the phone forensics guy to clean some stuff up, as Bloodworth said. And who else did they say they were going to call? I thought he said there were another witness, maybe Carmen. Cindy said these defense attorneys remind me of Donna Adelson's attorneys. The way this trial overlaps with Donna Adelson so much, because Kouri Richins gives me Donna Adelson vibes, and somebody else, I saw a clip where somebody put together Kouri Richins on the body-worn camera when police arrived with Wendy Adelson in her police interview, and it was like same. Like, they could be sisters. Hot Mess Express. As much as I don't want the defense to get their way, I agree, just drop it. Drop it for the sake of us, but also the defense is purposely making this difficult. And I think that's why the judge is so mad, because he's like, you're making this difficult and nobody can help you understand it because you're choosing not to understand it. Okay. Hang on, guys. I'll be right back. Mason wants his cucumber peeled. I'll be right back. Y'all just chat away and rant on. Okay, sorry. Yeah, and then getting mad at their own misunderstandings. The selfish part of me wants the continuance granted so I can make my trip to Costco. That's so funny because I keep getting alerts that my Sam's Club order's ready. Like, please come pick up your order. And I texted Matt and I'm like, can you just go straight from work to pick up the Sam's Club order? Because I cannot. But also, no, Nicole, we want this to get going. What honestly blows my mind is that the defense just seems so out of touch with reality and their evidence and the case law, and they have been on this case for years. Here we go. All right, I'm going to mute myself and put him back. Let's see what he says. I'm actually nervous right now. I think he went in the back and took some shot.
We're back on the record in 231-500-139. Counsel for the state and for defendant are present. Defendant is present. Ms. Lewis, the defendant, asked for a one-day continuance to allow time for defendant to, on the one hand, review the designations made by the state to determine whether there are some overt designations that go beyond what should be published under 801D1B, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which the
Granted.
defendant will take those positions in writing, by which the court and the state can review them, by which we can have a discussion on the record about which of defendant's positions are persuasive. And if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video, so that when we're publishing a video, not just pages of a transcript. Let's work backwards from there.
Mm-hmm.
How long is that process? And if you need to take a moment, step out and tell your video.
Okay, real quick. I don't think we're done for the day. The defense proposed that they move forward with testimony, have a 1-day continuance, meaning I think they said tomorrow off, or if they pause today, they have to submit something in writing today and come back tomorrow. And he just granted their 1-day continuance, whether that's the rest of the day today or whether that's tomorrow. It's kind of unclear to me, but they are wanting to scale down Carmen Lauber's transcripts and have them in video form so the jury can watch and listen instead of just having a bunch of transcripts posted on the screen. To me, it makes the most sense that they do the testimony and take tomorrow off, because that, I don't know. If I was the jury, I would be livid right now.
Video editor to press pause, I'd understand.
So the state will, within an hour or two, maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
Understood.
Now, depending on how much additional comes in and how much additional goes out.
Right.
Hard to say. 4 hours?
Okay. All right. As a practical matter, do you think we should start midday tomorrow or just come back on Thursday? I was hoping to come back midday tomorrow.
I literally cannot.
So we can do that, assuming was the court considering a deadline from defense something like 6 p.m. today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay. Ms. Lewis.
I'm truly speechless right now.
We're just discussing. I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only
What have you been doing
this
the
much
last?
stuff printed in 12-point font.
But
The Rule 106 designations would be immediately before or immediately after. And to the extent you're going to de-designate it, you're just taking stuff out of those. So that it's a relatively focused inquiry. You can go back and watch Carmen Lauber's entire direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you want to get more beyond this, I'm not sure you're entitled to do that.
I don't understand.
Well, if, for example, there's 200 pages of interview from with Jeff O'Driscoll the first time. And the state's just trying to put in 20 from the beginning. You don't get to skip to the end and say, well, these last 40 would be really helpful to us. We made a strategic choice not to ask Carmen Lauber about them when she was on the stand, but we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are from portions of all 7 interviews.
I agree, but they're not. They're just portions that are prior consistent statements. And so it's, did they over designate? This goes beyond a prior consistent statement. Or is there some stuff immediately before or immediately after under Rule 106 that's required to qualify, provide context?
Okay, but they got their way, and look at all 3 of them sitting there pouting right now. Like, they're still mad. You literally got your way, and you're sitting there pouting.
To explain.
Your Honor, can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement, it is rebuttal on reason motive to fabricate.
Yeah, that is the same. That's that's the prior consistent statement rule.
I think there were 2 separate things in 802D1, but maybe we're saying the same.
801D1B.
I mean 801D1, yeah.
is consistent with the declarant's testimony and is offered to rebut. So
Right.
it's the same rule.
Okay, got it.
I don't see you doing prior inconsistent statements based upon a lack of memory.
Nothing in A.
Right. I think we see it the same way.
Okay.
We have till 11 p.m.
No, I need time to read it. The state needs time to read it. This is possible. I want to make sure that we have a common understanding of
Together.
what you'd be permitted to do under 801D1B and Rule 106. This is not an opportunity to recross Carmen Lauber. If you want to recall her, I'm not making any statement about that. But to the extent there was stuff you wanted to put in your cross that you didn't, you're stuck with that for now until you recross her. If, on the other hand, there is an over designation by the state under the bounds of 801D1B, I need to know. And if, in defendant's view, there's a Rule 106 inclusion that's required before or after these designations, I need to know.
Understood.
Okay. So 6 p.m., we need it in writing, filed in the case, please. If you would separate out what you believe need to be de-designated versus what you need to be, what I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes.
Okay. Now, in terms of how to proceed for the remainder of today, do you want to put Kotradimus on and get him done, or do you want to break now?
Your Honor, if we can call him, he's 10 minutes.
Okay.
Some more time.
Any objection, Ms. Lewis?
Eating into our time.
All right.
Oh, okay.
Well, he's only going to be 10 minutes.
Yeah.
All right.
Take it out.
Okay.
Ramos back there.
Got
He's embarrassed right now.
And then we'll invite the jury to come back at 1 p.m. tomorrow. Does that sound reasonable?
Yes, sir.
3 p.m.
Okay.
after
Very good.
for us. The jury comes back.
Anything else before we invite the jury in, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.
The way she just said, it's cutting into our time. It's 10 minutes. And Ramos back there saying it's fine. I'm just like speechless with these people today. And I feel bad. Like, I figured when the judge went on break, he was like, he knew he was granting the continuance and the jury home. Clearly he didn't. Oh, Ramos is like wanting to crawl in a hole right now. Kouri, go back to jail. Have fun with your besties in jail. Like, an entire day wasted. Like, I'm not gonna lie, my ADHD, I couldn't focus through half their arguments this morning, but I can't say it's been 100% boring from like my perspective, but yeah, because we got to see the defense and their dramatics. And the way those three just act like the exact same person, like copy paste, it just gets under my skin.
We still have Taylor and you. Yeah. What's that?
Oh, they're big mad, and this is what they asked for.
Have a seat as you come in. Thank you. Have a seat. Thank you. Ladies and gentlemen of the jury, I greatly appreciate your patience while we work through some legal issues. We will proceed with a witness from the state, and then I have some scheduling notes for you. Mr. Bloodworth. Oh, Ms. Sherman, my apologies.
No problem, Your Honor. Chris Kochademus, please.
If you step in front of Brady.
Please raise your right hand.
They could be looking
Do
at
you
this
solemnly swear the testimony
Right
you're
now.
about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank
they
you.
could already be working.
Good morning.
Good morning.
Although the jury knows who you are, I'm going to have you state your name and spell your last name for the
Yes,
record, please.
It's Chris Kotridimus, Kotrodimus.
Now, we brought you back to talk about a couple specific issues. We know from your prior testimony that when you reviewed data from Eric Richins' phone, specifically for February 14th, 2022,
Yes,
you looked at the Verizon call records.
correct.
Those included text messages.
They did.
And that's the raw data that we talked about throughout your testimony.
Yes.
Is that right? And tell the jury, for an outgoing message from Eric Richins, how would Verizon list that time zone in their record, in their call record, that raw data?
It would depend on what type of message it was. For an SMS text, which is just a normal type text, it would route it through their normal server. It would be in local time. For MMS, that message has to be routed through a server. And so they use the server to route that call. And it would have a timestamp for the location of the server, not necessarily the device.
So when you looked at those records, the outgoing messages for Eric Richins' phone in the Verizon records, what time was reported for an MMS outgoing from Eric Richins' phone?
So there was an outgoing, in the record, there was an outgoing MMS at 12:23 p.m.
Would that be 12:23 p.m. in Utah?
No,
So what would the time of that outgoing message be for us in Utah?
we're 2 hours behind. So it would be 10:23 a.m.
Scott, if we could put up 3-14D, please. This was previously admitted in Mr. Kochademus' testimony. We can publish it to the jury.
Okay, there you go.
So we entered this exhibit through your testimony last time, and we talked about this gap in activity from Eric Richins' phone. And so what you've just described conforms with the raw data. Is that right?
Yes.
And describe it again now that the jury can see the time frame we're talking about. If a call record or a text message MMS showed outgoing from Eric Richins' phone at 12:23 in the raw data, you confirmed that that would have been 10:23 in Utah.
Correct.
How did you verify that?
So one, just the knowledge and experience of knowing that that's how Verizon routes MMS messages. they use an Eastern time zone, which is consistent with their headquarters location. So to verify that, for time zones are very critical for analysts, obviously. So what you would do is if you have a source to look at the original text, and in this case we do, which would be Eric Richins' his phone extraction, his cell download, I would expect to see, based on the time difference, an outgoing MMS text at 10:23 a.m. versus 12:23 p.m. And I did find that there was an outgoing message at 10:23 a.m., an MMS message to that number, and it was a photo.
So essentially, through your analysis and changing the time zones as necessary, this exhibit is still accurate.
Yes.
Scott, if you could put up 3-39D, page 5, please, for the witness. This has previously been admitted. And you can publish it as well. And you can blow up one of those messages or. So now that we're talking about time zones, describe for the jury how we get to the times that are listed in all of these text bubbles. And so that the jury knows all of the messages that we have entered have these timestamps on them.
They do, yes.
And how do we get to the time that is on there?
Okay, time zone issue again. Okay, so phone extractions from software are provided, those readable files are provided in UTC 0. So to determine local time of when that activity on that device happened at the local time, you have to adjust. So Utah is -7 UTC during normal standard time. It is -6 UTC in daylight savings. So we just switched on Sunday. So now everything until November, when we switch back again, will be -6. So the -7 and the -6 denoted in these messages is a adjustment that is made by the software to denote local time versus software time.
So for each of the messages that the state submitted in this case, they have been adjusted to local time.
Yes.
Okay, those are all my questions.
Sure, thanks.
Mr. Ramos.
No questions.
Okay. Sir, you can step down. Thank you.
Thank you, sir.
All that whining for not even 10.
Council will proceed with the scheduling notes, correct?
Yes, Your Honor.
Ms. Lewis?
Yes.
All right. Ladies and gentlemen, I appreciate your patience this morning. We've been working very hard on some legal issues that will materially increase the efficiency of the presentation of evidence going forward. I know it's hard for you to know that, not being in the courtroom. I'm just asking you to take my word for it. We have more work in that regard to do. Rather than have you sit here while we do it, we're going to send you home for the day and not ask you to return until 1 p.m. tomorrow. So we will recess until 1 p.m. tomorrow. As always, during this period of recess, please do not speak about the case with anyone. Do not allow anyone to speak about it with you. Please do not watch, listen, or read anything about the case. Please do not do any research of any kind. I greatly appreciate your patience. Travel safely. 1 p.m. tomorrow. Please rise for the jury.
Kouri looks so mad. I've never seen her look this mad during trial. I think she's mad about this continuance. Or she's mad that the testimony of Carmen's coming in. I don't know. She looks pissed. Did you like that, Terry, with the circus music?
All right, folks, have a seat. Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Lewis?
There.
Ms. Nestor?
No, sir.
Mr. Ramos?
Hey, Judge, no.
Okay. 8:30 tomorrow morning. Please travel safe. We'll be in recess. Thank you.
I make myself laugh sometimes. Okay, so court is done for the day. I don't even know how to recap that because I don't even know what happened. Besides a whole bunch of whining and crying and throwing their hands in the air like, we don't even know what's going on here. What are we doing? Why are we here? She wasted an outfit for that. That's so funny. Actually, her mom brings clothes daily and gives them to the attorneys. The attorneys give them to Kouri. She changes in the back, and then before she's even transported back to the jail, she's back in her jail clothes, and the clothes go home with her mom. So, which is kind of funny because there's been so many allegations around her mom. It's kind of wild to think that, wait, what just happened? Oh, that was weird. It went to somebody, it jumped to another stream. So there's so the attorneys are coming back at 8:30 a.m. to have the judge rule, like finish up the rest of this argument. Everybody's going to need to look at it and make sure the redactions are made. And then the jury comes back at 1 p.m., which is 3 p.m. our time. So I will plan on being live at 8:30 only, or no. Yeah, I guess 8:30 their time, 10:30 my time. It only feels right that we finish this out, these arguments, and see how the final ruling ends up. And then whenever they're done with that, I'll end up just having to end the live because I won't be able to come back live at 3 p.m. So it only feels right we finish this roller coaster out tomorrow morning over this whole argument. I still am trying to wrap my head around why we're spending so much time on this and why it's so important to the state to have Carmen Lauber's interviews in. I'm Eastern time. They're Mountain time. So I will set a live for tomorrow. So, Nicole, you're an hour behind me, an hour before them, and I'm 2 hours before them. So, yeah, that today was interesting just to watch the defense do what the defense does best. But I don't think anything got accomplished aside for like the redactions and the jail calls. This was wild. This whole argument over the transcripts of Carmen Lauber's testimony. I'm still not over the fact that we spent hours talking about that just for her to say, bring it all in, when this was brought up last week. So I guess we just got a whole morning of watching the judge, which is, can't complain about that. Anyways, I am going to shut the stream down, go outside, get some fresh air. I hope you all have a wonderful rest of your Tuesday. Now we don't have court for the rest of the day. Abby said, do you think Kouri really thinks she has a shot? I think she knows that she doesn't, but it's going to be through the lens of Donna Adelson, where it's everybody else is the problem, not me. The jury in this community has had it out for me. That's the way she looks at it. So I think she's prepared to lose, but it's not like because I'm guilty, it's because everybody else is the problem. That's what I think. Well, thank you for being here, Nicole. And I do think it's so much fun for all of us to get to chat together. Take it to, yeah, she's a narcissist. Can't argue that. And Emily said there are a lot of people I've seen online saying they believe Kouri. Mind-boggling. Yeah, I get DMs like every day. Are you sure that it's not the sisters framing Kouri? And it's like, what do they have to, like, their brother's gone? How would that benefit them at all. No, they're not framing Kouri. Yes, take it. Everybody have a good day. I'm going to end this now. I will be back tomorrow morning for to finish out this argument, 8:30 a.m. Mountain Time, 10:30 a.m. Eastern. Bye, guys. Everybody have a good day.